Hi, we are kicking off with the 50th session on liquidation under IBC. It reminds me that you have patience, with a lot of patience, heard about 50 sessions, 49 rather. This is the 50th session in which we are going to cover some more of the IBBI regulations, which we have started in the previous session. So let's quickly have a recap of what we have discussed in the previous session. In the previous session, we have covered from Regulation 3 to Regulation 8, which talks about appointment of liquidator. As I have been telling you before also, liquidator shall be independent. That's the crux of Regulation 3. And if he is not, he must inform the IBBI and adjudicatory authority. Regulation number 4 talks about liquidator's fee. We said it is basing on the value of the realization of the asset. It can range from 6% to 3% depending on how much is the amount of money realized through the sale of the assets. Then there is something called as reporting. After Regulation 4, we have Regulation 5, which speaks about reporting. Reporting, we said, can be preliminary report on sale of assets, and report which is a final report, and such reports. After that, we spoke about Regulation 6 that specifies registers, records and accounting of the corporate debtor, what should be maintained by the liquidator. Then Regulation 7 talks about appointment of various other professionals, how liquidator can appoint them and can he pay them money, and how does he recover the cost of engaging these professionals. Lastly, we come to Regulation 8, which is consulting with various stakeholders. Though we realize that liquidator has a right and power to consult various stakeholders, it is not mandatory for him to be bound by these suggestions or consultations. Hence, he can still take his own decisions in spite of the consultation. This is what we have precisely discussed in the previous session. Now let's go forward and start with Regulation 9 of IBBI regulations. Regulation 9 of IBBI regulations speaks about personnel to extend cooperation to liquidator. This is a very, very important provision within the IBBI regulations. In the past, we have seen that lot of resolution professionals and liquidators have struggled immensely in bringing about the resolution process of an insolvent, corporate debtor. Why was that? That is because the personnel, that is officers, employees and various other people involved in the operations of the corporate debtor do not actually cooperate with the liquidator or a resolution professional, and hence there are a lot of hindrances caused. So eventually the law became more cooperative. The law has been giving more powers to the insolvency professionals, liquidators, resolution professionals, and adjudicatory authorities especially have been giving a lot of orders which went in favor of the liquidators and resolution professionals. Now Regulation 9 of IBBI regulations talks about how the personnel involved in the operations of the corporate debtor should actually cooperate with the liquidator. The liquidator may make an application to the adjudicating authority for a direction that a certain person shall cooperate with him in the collection of information. Remember, these powers, though are inherent, these powers may be obstructed, these powers may be hindered by various persons. Liquidator does not have a man force or a legally binding power with him. Therefore, he might have to make an application to the adjudicator and seek an appropriate relief at the right time so that he will get cooperation from all the people surrounding him. So therefore, Regulation 9 makes it an obligation for insolvency professional to file an application to the adjudicating authority seeking a relief where he can get cooperation from various people involved. A liquidator can get this order from the adjudicating authority against whom? That's a very important question. So the following are the personnel against whom an order can be made by the adjudicating authority on the application of a liquidator. Number one, officer of the company who's involved in administration, who's involved in operations, who's involved in manufacturing process or finance or any such officer. Then the auditor of the corporate debtor, employee of the corporate debtor, promoter or any partner of the corporate debtor in case if the corporate debtor is a partnership like LLP. Then any person who was in the past an IRP or an RP or a liquidator of the corporate debtor with whom there is a lot of information available, the liquidator presently appointed for the case may seek information from all these parties. Lastly, any person who is believed to have information of any property belonging to the corporate debtor, against all these people, liquidator may get an order from the adjudicating authority. And remember, the crux of the order is cooperation. Provided an application can only be made if the liquidator has made reasonable efforts to obtain the information and has failed. Remember, adjudicating authorities are very busy actually deciding more important matters in the insolvency issues. Most of the process should be handled by the insolvency professional who is appointed to handle the case. But if he is coming back to adjudicating authority every now and then seeking some or the other relief, then it results in lot of time consumption unnecessarily for adjudicating authorities. Hence we are saying that as a liquidator, you first make your reasonable efforts to get the information from the persons involved. If you fail and if you face any kind of an obstruction, only then come to the adjudicatory authority, otherwise handle it yourself. Let's come to regulation 10, disclaimer of an onerous property. In the session number 48-49, we have heard of onerous property, and I've explained it to you that onerous property is a property on which the expenditure of maintenance and fighting the legal battles is much more than the value of the asset actually. Hence, having such asset will not make any sense, and therefore the liquidator might disown this asset. But however, the decision is not his. He has to make an application to the adjudicatory authority, and adjudicatory authority may by order allow him to disown such asset. So regulation 10, this refers to property that is burdensome or subject to liabilities. In case of insolvency, if a debtor's assets are encumbered or pose a financial burden, they can be classified as onerous property. Regulation 10 allows the insolvency professional to disclaim ownership of any onerous property that could adversely affect the insolvency process. This means insolvency professional has authority to reject the property if it is detrimental to the interest of the creditors or of its liabilities outweigh the benefits. The purpose of this provision is to help streamline the insolvency process by removing unprofitable or problematic assets from the estate, allowing a focus on assets that could generate value for the creditors. Now we move on to regulation 11 that talks about extortionate credit transactions. If you remember, we also talked about section 49 and 50 that dealt with extortionate credit transaction. 49 about fraudulent transaction, 50 and 51 precisely on extortionate credit transactions. Now regulation 11 of IBBI also talks about same transactions. Maybe some of you are thinking that if there is a provision in the law dealing with a certain topic or a matter, why would there be a regulation on the same matter again? The reason is very simple. The law, the enactment framed by legislators is rather very rigid. It is not very flexible, right? Therefore, any enactment generally gives a basic framework within which the law should operate. However, the same law, legislation, will give powers to the regulators who can make regulations from time to time which will govern the processes mentioned in the entire law. And these regulations are slightly flexible in nature. Hence, the regulator can keep on modifying them from time to time. Every time you need not go back to parliamentarians for amending the law. Hence, regulations play a significant role. Therefore, sometimes you see that the enactment and its provisions are overlapping the regulations, or regulations overlap the provisions. As far as they both can operate independently, both of them are valid. But if there is a conflict between the enactment and the regulation, enactment will be valid and regulations will be inferior to enactment. Therefore, they may not be valid if it's a direct conflict. So, having said that regulations also deal with extortionate credit transactions, we are specifically focusing on Regulation 11. A transaction shall be considered as an extortionate credit transaction under Section 50, subsection 2, where the terms require the corporate debtor to make exorbitant payments in respect of credit provided, or are unconscionable under the principles of law relating to contracts. So, are they reasonable or unreasonable? The moment element of unreasonability arises, it is almost likely to be termed as an extortionate credit transaction if the credit terms are absolutely unreasonable. Then, Regulation 12 talks about public announcement by liquidator. In previous sessions, we have understood that public announcement is an important element of the entire liquidation process because he is going to invite the claims again. So what is Regulation 12 saying? The liquidator shall make a public announcement in Form B of Schedule 2 within 5 days from his appointment. 5 days, remember this timeline. The public announcement shall call upon stakeholders and are required to submit or update their claims as of the liquidation commencement date. So we said whatever claims that you have submitted at the time of CIRP, that is a different story. But as far as liquidation is concerned, it is a fresh process under the order of the adjudicating authority. Hence, the creditors and all claimants must lodge fresh claims, either modify your previous claim or lodge a fresh claim, but liquidator shall have a record of all these claims once again. The public announcement shall also provide the last date for submitting or updating claims, which is 30 days from the LCD, which we call as liquidation commencement date. There is a part C to the whole provision. It says where a stakeholder doesn't submit claims during the liquidation process, the claims previously submitted and collated during the CIRP will be deemed submitted under Section 38, and hence maybe he need not make a fresh claim if he doesn't have anything to modify. The announcement shall be published. This is important. If I am a creditor of a company which is under liquidation, I will not get any personal communication from the company that the corporate debtor is under liquidation and hence I have to make a claim. So what is the only way of I as a creditor knowing all about liquidation process and the claims is that I will have to follow the newspapers where the advertisement is made and public announcement is made, and actually make my own claim basing on this public announcement. However, the question is, who is reading which newspaper, right? Maybe I don't read newspapers at all, or I might read a local newspaper which is published in vernacular language, and somebody else might read a newspaper which is published in national language. Hence, it is important to understand where should this public announcement be published, especially if it's a newspaper? Please follow this carefully. It should be made in one English and one regional language newspaper having wide circulation at the location of the registered office. Let's quickly recall, how many newspapers do you remember which are circulated in your locality, either in English or in vernacular language? Most of us may not remember any newspapers at all. So, if I am publishing the public announcement in a newspaper which is having the lowest circulation and probably nobody reads that kind of a newspaper, then it is impossible for the claimant to get this information. Hence, the law says, especially IBBI regulations, say that you must publish such regulation or you must publish such advertisement in such newspapers which are widely circulated at the location of the registered office. Though you might have 100 different offices, we don't care. Registered office is the key as far as we are concerned. It must also be published on the website, if any, of the corporate debtor, and lastly on the website, if any, designated by the board for the purpose of such public announcements. Then regulation 12A, process email ID. This is also very important provision which says that liquidator must use process email ID which is specific to an account. If I am an insolvency professional, I have my personal email ID. If I am inviting emails to my personal email ID, I might have enormous number of emails, I might lose track. Therefore, all of us insolvency professionals, what we do is we open a separate email ID to a specific CD's account, whether as a RP or as a liquidator. So, all the correspondence with reference to such corporate debtors account will come to that email ID. This liquidator must use the process email account provided by the resolution professional following regulation 4C. In the event of his replacement, email credentials must be transferred to the new liquidator, and remember, whoever may be the liquidator, there is only one email ID to the corporate debtor about that liquidation process. Therefore, the liquidator may change, but the email ID will not change. As we discussed, there are some important reports to be delivered by the liquidator periodically. So we are trying to understand what are those reports. The liquidator must submit a preliminary report. Remember this word. This is the first report ever submitted by the liquidator and hence called as a preliminary report, though he doesn't have many details about the corporate debtor. This preliminary report shall be submitted within 75 days covering corporate debtor's capital structure, estimates of assets liabilities as of the liquidation commencement date. The liquidator must submit a report within 75 days covering the first two plus also 3-4, which is plans for further inquiries, if any, into debtors' promotion, formation, business conduct, and a proposed liquidation plan. Remember, this is a key star point of the entire preliminary report as to how does he plan to complete the liquidation process and what are the timelines and the estimated costs of liquidation. This is regulation 13 that we have covered. Now we move on to regulation 14. Regulation 14 talks about early dissolution. After preparing the preliminary report, if the liquidator finds that the debtor's realizable properties can't cover liquidation costs, no further investigation is needed, then he must consult the consultation committee and, if advised, apply to the adjudicating authority for early dissolution with a detailed report. Because now we know that there is no realizable asset and it does not make sense for us to proceed and no further investigation into these proceeds is required or assets is required, then Talk to consultation committee, take their opinion and apply to the adjudicating authority for dissolution straight away. So there is no liquidation process that is involved here. When is that likely? If you think very simply, this is likely to happen when the company does not have a single realizable asset. It has zero assets and more liabilities. Then it's a waste of time to even run the liquidation process. Then therefore directly dissolve the company is the best solution. Progress report, we have earlier seen a preliminary report and now we are talking about a progress report. Liquidator must submit progress reports to the adjudicating authority and the board as follows. The first report within 15 days after the end of the quarter in which the liquidator is appointed. So if the liquidator is appointed during the month of July, I'm repeating, if the liquidator is appointed during the month of July, the quarter will commence in July and end in September. So July, August, September being the end of a quarter, from September 30th, within 15 days, the liquidator must submit his first report. This is the progress report. Then subsequent reports within 15 days from the end of each quarter. So if the first report has gone within 15 days from the end of September, the next report will obviously go within 15 days from the end of December, and after that every quarter whenever it ends, like March, June, September and December, you should keep on submitting one report within 15 days from the end of quarter. The progress report shall include, this is an important thing, the moment I am saying you must report, what is that I should report and what should be the content of the report. Firstly, it should talk about appointment, it should talk about tenure and cessation of professionals who are involved in the liquidation process. Then progress in liquidation, where did you start and what is the current position. The progress report must include details of fees and expenses, developments in any material litigation by or against the corporate debtor, filing updates on applications for avoidance of transactions under Part 2 of the code, which we have seen that there are avoidance transactions called as the preferential, undervalued, fraudulent transactions, and lastly extortionate transactions. If you have filed any of these applications, then you should also report the status of those applications and details. Any changes in the estimated liquidation cost must also be mentioned in this progress report and then submitted. The progress report must include an account showing liquidator's receipts and payments during the quarter, the cumulative total of receipts and payments since the liquidation commencement date till the end of the quarter for which he is filing the report. So this brings us to the end of today's discussion on the various IBBI regulations, which includes the following regulations that we have discussed. Regulation 9, we understood what is the order that the liquidator can obtain against the personnel for cooperation. Regulation 10 talks about disclaimer of onerous property. We should make an application and disclaim them. And extortionate credit transactions, we can take an order. However, remember there are conditions as to when you can actually call them as extortionate transactions, that is given in regulation 11. Then we come to 12, you should make a public announcement within 5 days. Then 12A talks about creating a process email ID specifically for a liquidation account, and that should continue. 13 talks about preliminary report, which should come within 75 days. And then we talk about early dissolution. If you find there is no realizable value to the assets of the corporate debtor, you can make an application to adjudicating authority and call for an early dissolution. If the authority is satisfied, it can order a dissolution. And lastly, progress reports must be filed on a quarterly basis. In the case of a first report, at the end of the quarter in which is appointed, within 15 days, and after that every subsequent quarter you must file a report within 15 days from the end of the quarter. So friends, this brings us to the end of 50th session. I congratulate you for patiently hearing to 50 sessions. We look forward to the next sessions again on IBBI regulations and further studies. Thank you.